The amendment would introduce a new provision to Section 145 of the Constitution regarding motion of no confidence in the Prime Minister. The initial bill is to prevent a vote of no confidence for 18 months if a previous one fails.
Nomane, who filed the application under Section 18, subsection 1 of the Constitution, argued that if Parliament proceeded with the amendment, his substantive case would be rendered futile.
The court refused my application on the grounds that the Supreme Court lacked jurisdiction, as it could not interfere with parliamentary proceedings, and in so doing, it enforced the separation of power espoused in Section 99 of the Constitution. In protecting the rights of members of Parliament to have freedom of speech, to debate, and to engage in parliamentary proceedings consistent with Section 115, subsection 2 of the Constitution, my interim injunction to prevent Parliament from deliberating on the proposed amendment to Section 145 was refused.
However, the court ruled that violating such an order would violate the rights to freedom of speech and debate in Parliament as enshrined in Section 115, subsection 2 of the Constitution.
It's very important to note that on paragraph 3 of the decision, on page 6, paragraph 3, the decision further states that the proposed amendment would have nil effect on the vote of no confidence, since the proposed constitutional amendment would operate prospectively, not retrospectively. Now, what does this mean? The difference between operating prospectively and retrospectively. That means that a motion of no confidence in the Prime Minister can be moved at any time, after which this proposed amendment, if it goes through, will kick in.
The court also held that the applicant failed to demonstrate that an interim order was necessary to prevent prejudice to his case. The application for the interim order was therefore refused, with the applicant ordered to pay the intervener's costs. The decision underscores the court's position that the Parliament's legislative processes, particularly debates and proceedings, are protected by constitutional provisions and cannot be interfered with through judicial orders. The case is adjourned to 14th of March for hearing of the substantive matter, and orders that applicants to file submissions by March 7th and interveners to file a response on March 10th. Meanwhile, Nomane added that he stands firm with his call for Prime Minister James Marape to resign.
Absolutely. The Prime Minister has lost the moral authority. There's no respect in this Prime Minister across the country. And we can see this in the total deterioration in law and order, and the fact that this Prime Minister has absolutely no idea, after 6 years of being the Prime Minister, to fix law and order, to fix the economy, to create employment, to reduce inflation. He's got no idea. If you've got no idea and you're promoting a kakistocracy where you are appointing the least qualified members of Parliament to be in key ministerial portfolios, we are just taking the country on the freeway express lane to becoming a banana republic. So absolutely I stand by my call that the Prime Minister should resign for his failure in the last 6 years to improve the socio-economic indicators and the living standards of Papua New Guineans.
James Guken, National EMTV News.